as interactive as much as we can, because this is an emotional area. We know for the country, for anybody in any jurisdiction, when you have to retrench workers, make people lose their jobs, it creates some kind of uncertainty on the part of the employer and also the employees. So it's a very touchy area, and we would like to learn from one another in the course of the session. The scope that we'll be covering today are basically 6. First, we want to understand the meaning of redundancy according to the law, case law, and regular practice, as we have seen. Instances where redundancy can arise. The difference between redundancy and termination of employment, because there is a tendency to mix it up sometimes. Conditions for redundancy, what are the things that have to be done for a successful redundancy to take place? The assessment of redundancy benefits that are payable to affected employees, as well as statutory deductions and other information that we may have to pass to one another as we go on. So, the meaning of redundancy. Under our Labor Act, it simply says that redundancy is the involuntary and permanent loss of employment caused by excess manpower. That's Section 23 of the Labor Act. So what it means is that the employees must not have resigned, whether voluntarily or involuntarily. It's not a resignation. It is also a situation that arises where there is excess manpower in the employment of the employer, and the position that was previously occupied by the redundant employee would ordinarily not be filled with new workers. So instances where a company may compel or cajole employees to resign, for example, would ordinarily not be categorized as a redundancy. Although I'm aware that in some companies, like multinational companies, using the industry that I'm a bit familiar with, I know that when oil prices went down and most companies were pressed to cut down on costs, companies that had the money and had some kind of good rapport with their staff base, they were able to speak with certain people that they felt had been in the service for a very long time and whose retirement was likely to come up very soon, like in the next few years. And they were able to get those people to resign, get their terminal benefits in order to enable the company manage the people on board. So in such instances where people resign voluntarily and take whatever benefits that are due to them, that is not a redundancy in accordance with our laws. Also, where you sack somebody and you employ somebody else to fill in that position, that is not a redundancy. As a matter of fact, most regulators in industries where regulatory approval is required would want to understand the employer's plan for continuing that job scope that was occupied by the redundant staff. So if staff is being redundant, does it mean that the work the staff was doing will no longer be executed, or do you plan to transfer that work to an existing staff, thereby increasing the scope of somebody else's work? Or do you want to employ somebody else to do that job? If you're employing somebody else to do the job, then it's not a redundancy. So this implies also that the employer's release of an employee from his employment in certain industries. Okay, what we are trying to say in this second bullet point is that in some industries, a redundancy appears to be confused with termination of employment. In the oil and gas industry, for example, there is the DPR guidelines on the release of staff in the Nigerian oil and gas industry. It's a 2015 guideline. And it's not entirely new because it stems from a 1988 regulation of the DPR, which is made pursuant to the powers of the Minister of Petroleum Resources under the Petroleum Act. And right from 1988, it had always been a requirement for companies in the industry to get the regulator's approval before terminating employment of people or any person in the industry. But the most interesting part, I think, is aside from the fact that after 1988, there was a reminder by way of a circular from the DPL to companies in the early 1990s. In 2015, it was kind of solidified with a proper regulation that states that requires every company, whether the company holds an oil mining license, oil prospecting license, oil mining lease or prospecting license, marginal field, or even a service provider in the industry, requiring all those companies to go to the DPR and notify the DPR before sacking any employee. So, because the instances where the consent is required also includes redundancy, although it's not expressly defined, also includes termination, voluntary or involuntary loss of job, and other instances stated under that regulation. So that's almost like moving to the other aspect that we are going to talk about later. It's almost like confusing redundancy with termination, and that's because of the implication of those two principles. We've seen that the courts have also defined redundancy in a previous case as occurring where the services of a worker that have been in continuous employment of an employer are no longer required by the employer due to no fault of the employee. So the teaser for me here, based on the court's definition, and I see that it's a 1988 decision, is okay, you're saying a worker who has been in continuous employment of an employer. What does that really mean? Does it mean that somebody who was employed within a year and was confirmed and the person's employment was terminated will not qualify as having been redundant? I think there are also some cases as to employees who are under probation and who are asked to leave the employment due to no fault of theirs, whether that will qualify as a redundancy. Those are things that we will discuss further as we go on.
Okay, so then I think you moved the slide too fast.
Sorry, let me take it back to. Beg your pardon. Okay.
Okay, so while Nana is trying to go back to that slide, I think we're trying to talk on this slide about where redundancy takes place. So instances that necessitate a redundancy. I mean, in this part of the world, and I think in most generally, we see that companies embark on a redundancy exercise where that company is undergoing economic difficulty. But other instances where companies embark on a redundancy exercise, we have listed some. I won't go through each one because I'm sure we can all read. So I'll just speak on some that I have seen. So we've listed them not in any particular order, but I'll just discuss them as the more frequent ones, the ones that I have come across and I think are more prevalent. So the first is change in business model. So this is reorganization of a company to enhance efficiency of that company. We see that a lot of companies, for instance, the one I work in, we constantly have to reorganize how the company works to ensure that we don't have more heads doing less work. So in a lot of businesses, certain functions are moved out of the company. So for instance, that's also where we see this concept of outsourcing. Key functions which are not key to that company's business are typically taken out of the business, and then the employees working in that function are then made redundant. Another popular or common instance where a company carries out redundancy is where there's a merger or an acquisition. There's also, I guess we all understand why that would be necessary. We also have modernization or basically technological intervention. So if we can do things with tools, I mean, and that's what we're seeing now, where a lot of things are done through tools. So I'll give you an instance. A few months ago, I was asked to attend a training, and in that training, it was talking about how there's a particular tool that can assess contracts. So basically, you put your contract into the tool, and the tool will tell you the clauses that are not beneficial to your company. So it would first ask you, are you the buyer or the seller? You put your once you put your contract in, and we tell the clauses that are not beneficial to you as say for instance, a buyer. It will suggest you alternatives. It will schedule a meeting with you with the seller. So, I mean, if that tool was to take effect, I imagine that the entire legal department will be made redundant, right? So that's what we mean by technology, by technology here. Another case is a discontinuance of a part of the business or winding up the business. So these are instances where we see that companies embark on a redundancy. Though none of these are provided for in the law, in the Labor Act, we find there are certain court decisions where judges have listed some of these grounds for redundancy. But what I would say is that for whatever reason it is that a company is carrying out the redundancy, it must be clear. It must be something that the company can prove in the event that that company is challenged about this exercise. So you must have facts. So for instance, if it's that you're no longer performing that business, if you've sold that part of the business, you must be able to show that you've sold that part of the business. If it's that you're restructuring the business for efficiency purposes, you must be able to show the structure, how what the existing structure of the company is and what is going to be after the restructuring, just to show that it's not flippant. The company is not being mischievous or just unnecessarily trying to let employees go. I must say that this is more particularly so. This is very crucial in a unionized environment because every step is questioned by the union. So you would be expected to be able to evidence whatever it is that you're putting forward to the employees or the union as the grounds for carrying out a redundancy. Okay, Nana, please can you go to the next slide?
Okay, thank you, Tutu. But if I may just add something on this slide, like you and I were discussing earlier, and I was just thinking that perhaps people should just be mulling it on their minds on item D and E because they are correlated. I think the take home for us as lawyers, or maybe an assignment for us, those of us in the legal profession, if your client sells his business or merges with another entity, and by implication, like we know how it's popularly done in not just this part of the world, most business circles, you just change the shareholders at the top, change the board of directors, and when necessary, you change the name of the company. The employees remain the same. The terms of employment continue as though nothing happened. But in such instance, if you have some employees that say, okay, we actually understood X as being the owner of this company, as being our core employer at the time we were engaged, and now we understand that Y has taken over the company and Y is now the core employer. X has exited quietly. So we have a new employer that we did not execute a contract of employment with. And for that reason, we are not interested in working with this new employer for reasons best known to them. It could be a reputational issue, that they do not want to work with that entity. So what happens in such instance? Because I was just thinking that, okay, could we say that a redundancy had occurred there because those people are no longer engaged by the entity that had employed them. And if you say, okay, you have not been rendered redundant, and if you don't want to work with us, go ahead and resign. The implication is that the employees will not be entitled to redundancy benefits that they ordinarily would have got if a redundancy was declared without trying to cut, I don't want to say cut corners, but that's almost what it is like. So how are we going to treat that if we are faced with such circumstance? Perhaps there may be case law in other jurisdictions that anyone who is aware of could share with us in the course of the presentation. And also, let me just talk quickly on a modernization, like Tutu was trying to say. You go and bring a technology from maybe a 2018 technology from anywhere and bring it to your company without training staff to acclimatize with that technology, and you say, okay, you guys don't know how to use this thing, we are going to sack you and bring the people who can work on it. That is a redundancy. You will not say the employee is incapable of performing the job. But the interesting thing is, I think I read a case in the course of preparing for this presentation, where the court said, okay, employees are supposed to continuously improve themselves. So if it is something that the employee is expected to know in its ordinary course of performing his duties, things that he should have improved upon in the course of working for the employer and was not able to improve on and thereby became incompetent to perform the job, then a redundancy will not be said to have occurred.
Okay, so
just to sorry to butt in, I wanted to clarify something. I don't know how you ladies want to play it. At what point are you willing to take questions or comments?
can we take this at the end of the
Because I have at least one. Okay then. Okay then. Thank you.
Okay, so sorry, everyone, we'll just implore that you pen down your questions because we know it's easy for one to lose one's train of thought. There will be a lot of issues that I'm sure we'll identify as we go on, and we'll not want to lose the benefit of the questions that you may have or comments. So if you could pen down your questions, and at the end of the presentation, we'll all go over them. Thank you. To carry on, please.
Okay, thank you. So this slide here, we're talking about the differences between redundancy and termination. Nena mentioned at the beginning of this presentation that sometimes this is confused. So what we've tried to do here is to highlight the differences between a redundancy, when it will be construed as a redundancy and when it's a termination. So, I should point out quickly that redundancy and termination are construed very differently under the law by the courts as well. So while termination is as provided for for termination under the law for workers is clearly stipulated and how you can go about this. For those who are not guided by the Labor Act, this is in accordance with the employee's contract of employment. A redundancy, on the other hand, is defined clearly under the law. At the beginning of this presentation, Nana also defined, also read out to us what it is that the law provides as a redundancy. So in terms of notice, okay, so for a redundancy, the first thing is that I should point out, and I think that's the point, is that for redundancy, once you declare a position redundant or a role redundant, you cannot replace, you cannot rehire in that same position for a period of time, because what you're saying is that there no longer exists any work for that person to perform. So you cannot 2 months or 3 months out, like, suddenly realize that in actual fact, there's that position is required, you cannot replace that job for some time. Another difference between, while for a termination, you can do so. You can let someone go today and then replace the person immediately. Also, for another difference between a redundancy and a termination is that for redundancy, because it is construed very strictly by the law, you're required to engage the regulators. So you would need to inform the Ministry of Labour of the fact that you're going to carry out a redundancy exercise, where for a termination is as per contract. You would, whatever notice is required under the employee's contract, you follow. Also, another difference is in terms of the payments that you make in each case. While for termination, you're only required to pay in lieu of notice. For redundancy, you're required to pay a benefit, or because you're putting the person out of job. It's or out of work. For no action of that person. So you're not saying that the person is incompetent or whatever. You're just basically saying that you've done nothing, but I no longer require service. So we find that redundancy payments or redundancy benefits are much higher than, they're quite steep, as opposed to a termination where you would only pay salary in lieu. Well, here we've said that for termination, you really don't necessarily require to give a reason for termination, but I'm sure that we've said this on the group where we've said that NIC is certainly leaning towards international practices and is asking that a company give a reason for termination. But generally, you don't have to give a reason. A contract of employment typically allows an employer to terminate an employee's contract without reason. But on the last point, which is that while a termination will happen one at a time, a redundancy would happen, would affect more. From experience, the question I usually ask is, at what point does a termination become a redundancy? So for instance, if I carry out a termination, one termination a month, after 6 months, would it be construed as a redundancy, or is it still considered a termination? So for me, that's a gray line, and I don't think anybody has been able to answer that question for me. So I'd appreciate any responses from anyone on this group on that. But what I typically err on the side of caution, and I would say that if it's one person in 3-4 months, and it's not related to anything else, maybe it's nothing, you can't tie to anything. Yes, I'll take it carried out as a termination. But once you think that a few other people might be affected within a short period of time, then I'll say that just follow the redundancy procedure. Though, lawyers don't want to follow that because it's a more stringent process. Also, while I've said that a redundancy affects more people, I've seen a case where, a situation where redundancy can be one person. So for instance, if you have 1 or 2 people, so if in a department, if you're shutting down a department, like we said earlier, if you're no longer carrying out this particular business. So for instance, if you have an internal logistics team and you no longer want to do that and you want this completely outsourced and it's a team of 1 or 2 people, that is a redundancy, even though it's only affecting 1 or 2 people. So it's not strictly a numbers game. It's not a matter of, okay, if it's 6 people, then it's a redundancy, or if it's 1 person, it's a termination. But typically, if you find that redundancy affects many more people than the ad hoc termination. Yes, so for redundancy, yes, we've said here that it requires rigorous engagement and communication, not only to the employee, but to the union where there is one. Also, good practice, something we have here is that in addition to the engagement, what we also try to do is to give the person options. So there's a long process of engagement with this person. So even before you say to this person that, oh, you're going to be let go, you start to put it out there that, okay, look, there's going to be a redundancy exercise. It would affect certain, and you list the roles or the departments or functions that it would affect, and give these people an option to apply for other positions within the company. So sort of give them, opportunity to move around. Where this is still not possible, you can then also give them, what we do here is also to educate them on things that they can do with their time, with their money, and all of that. So we would typically have subcontractors approach them, if they can use their services, or also have pension, or this is how people come and talk to them as well. Just basically give them a soft landing so that it's not, put a human face to the action, as opposed to a termination, which is not as humane. It's colder in effect. Okay, I've spoken about the second point, which is that in fact here, we can't replace a position, I think, within 2 years after it is declared redundant. Okay, we've mentioned that it requires regulatory approval. Yes, you must give a reason for the redundancy, and it's not voluntary or forced. So yes, a redundancy should not be considered as voluntary or forced retirement, resignation, dismissal, or termination. Also, once in carrying out a redundancy, it must be clear that it's not performance-based. So if it's performance-related, then that should be treated as a termination, or because if you're going to say that it's based on performance, then you need to show that the person has gone through training and whatnot. But if it's redundancy, then you must ensure that people who are affected by redundancy are not people who either have performance issues or misconduct or whatnot. It's clearly that the jobs no longer exist. Nana?
Okay, thank you, Tutu. Just to say something on the question you asked as to when redundancy will be said to occur, when it just affects one person, like if the employer terminates or renders employees one employee redundant at a time, say every quarter or every month. I found it interesting that I read a case, also a very old case, which I'm happy to share after this presentation, where the woman she was working in a company, and a new entity acquired that company and gradually started laying staff off. So over a period of 6 years, they laid off a number of people in small brackets. And one day it became her turn and she was asked to go. So it takes one person challenging the status quo for things to be clear. And she went to court and said she had been rendered redundant because they just paid her terminal benefits. And she was asking for her redundancy benefits because she had worked with the former entity for a period of time and was transferred to this new company. And the court agreed with her that the history of the entity had shown that it had laid off staff over a period of time. It had taken care to do it in steps, not to alarm the public or notify the regulators. And in her case, as well as other cases, a redundancy had occurred and the company was mandated to pay her redundancy benefits. So I think the facts of the case would reveal if somebody is bold enough to challenge it. Then also, just to add to the point on refilling the redundant position, I worked with clients who had a very touchy redundancy issue. Over 100 personnel were laid off, and it was a very emotional moment because people were crying. You see full grown men, saying that they still had children at school and they were not sure of how they could go on with life and have when they quit the job. So the company was exiting Nigeria, but was going to leave the country slowly. So we decided to lay off staff and have an alternative arrangement where people will be hired temporarily through outsourced labor to perform the services of the company up to a certain period of time. And the consensus we reached with the Ministry of Labor at the time was that these people who had been laid off would be given first consideration in filling up those temporary positions. So even if you do not plan to fill the position permanently for a period of 2 years, if you intend anyone to do that job, it's advisable to consider the people who had left, who had been rendered redundant within the immediate period prior to you wanting to fill the role. Okay, conditions for redundancy. Now, these conditions are actually important. I remember then when I was in the law firm, you know, when you're not in the heartbeat of the entity, and I'm sure Tutu will understand because she's currently probably wearing the shoes, but for me at the time, I was outside looking in, and it was almost like, okay, I don't understand why this is what the law says and why is it difficult for them to comply. But as time went on, I began to see that sometimes you just need to put a human face to it, even when the law is not very clear, in order to ensure that things move smoothly. Let me give you an example. At that time, we had a client who was providing services in the oil and gas industry and was also servicing companies offshore. And this company, for financial reasons, decided to exit the country and close shop. So somehow news that was going to happen had filtered out, and people panicked. They went on strike, and one of the strikes involved shutting down vessels offshore, putting out power, no catering services. You know, they just kind of grounded everything, and it was almost in fact, it was an emergency situation because we had to write to the Ministry of Labor and DPR at the time that lives were at risk because of what the unions were doing. So it's very important to follow the conditions. There is a point in time where confidentiality is key when the entity is yet to make a full decision on how it's going to go about the redundancy. It's advisable to ensure that you control information flow at that point. And once you're sure of what you're going to do, then you start communicating and communicate clearly. Because when there is trust, then the issues and challenges that may arise, because if they had shut down the vessels for a period of time, the IOC that they were servicing would probably sue the entity that was already lacking money for breach of contract. People would have fallen sick. Probably deaths would have arisen because of people who were in some medical facility using oxygen there and all of that. So first, you must have a clear reason for the redundancy. You know, why do you want to lay these people off? Why do you want to stop people from working in this position? And we have already given some conditions, or some instances that may cause a redundancy. So once you identify the reason, ensure that it's clear, that the employer itself clearly understands it, and that reason is valid. Because if you have to face a regulator, particularly the ministry, most times, if the reason is not valid, they almost would not agree to it, and you may find yourself continuing to pay salaries even when you do not have the ability to do so, and end up winding up the entity when it runs aground finally. Then next is to articulate the list of persons that will be affected by the redundancy. Ordinarily, the principle of last in, first out is to apply. That's the last people to be employed into the entity usually should be the first people to be laid off. So if you have somebody who has been working for 10 years and you have another person who has been working for a year, ordinarily the person who has stayed in the entity for 1 year should be asked to go first before you start to affect the people who have been in the entity for a longer period of time. But then this is subject to management discretion. So the employer has the right to say, okay, this guy has been working here for 10 years, but he doesn't have certain qualifications that he needs to perform this job. And the bulk of the job has been done by this guy who has just spent 1 year here. I understand that in the IOCs, there are a lot of issues like that. You know, people who were employed in the early 90s, who were highly qualified at the time, but for some reason have not really updated themselves. Of course, they are not going to be very easy for them to go back to school to get additional qualification. And then you have new young people who have 2-3 masters and have certifications from everywhere coming up, and they work for just 1 year and they're able to do 3 people's job at the same time. So if a redundancy is to occur in such instance, the entity is likely to consider the skill, the ability, the merits of the workers involved to choose, more like cherry picking who should be affected, but then it should be transparent. And that is why it is very important to have a performance monitoring record. Because I remember in a case I worked on, one of the problems the client had was that it had not been evaluating performance for a period of time. So it found it very difficult to justify why it had to keep people. It then became a question of, okay, MD knows that this person is doing the job very well. MD sees emails from this person. Can you justify that, okay, because this person sends more reasonable emails than the other person, you want to keep the person? But if you have like a performance assessment periodically that is done without bias, then the records are there to show who has been performing better than the other, and when you have to choose who you want to keep, there will be little or no dispute because the records will be there to speak for themselves, even if you are going to court or before the regulator. Even the unions will understand if you have records in the case of unionized employees. Some other factors that may be considered are age, you know, when, and health status, however unfair that may be. Somebody who has been falling sick, you know, has a lot of sick days in the year against somebody who is healthy, it's more likely that the employer will want to take the healthier person if he has to choose who to let go, as well as the younger person who he knows is likely to work for a longer period of time. Then when it comes to expatriates, I recall that at the time, one of the unions, NUPENG, who we know is actually tough, was challenging the fact that the employer wanted to let Nigerians go. There was some allegation that the employer was trying to let Nigerians lose their job in order to retain expatriates. So luckily for us at the time, we had records that showed that a very large percentage of expatriates had been laid off first. So as much as possible, ensure that the redundancy, the people affected are kind of, the list spreads across board. Expatriates, third-party personnel. If you have contract staff, no, not contract staff, outsourced personnel. For example, you are paying a company 150 million to provide you with personnel in a year, and you have expatriates that are paying, say, $20 million a year, and Nigerians who are earning a total of 100 million naira a year, and you say, okay, you want to keep these expatriates and keep the third-party personnel, but you want to lay off some of your direct Nigerian employees, there may be a problem there. So it's just practice. It's not written anywhere, but I've just learned that it's good practice to ensure that the redundancy spreads across board as much as possible, let it impact on every corner, even management, if possible. If there are people in management that you know you can affect, maybe bring them in another way through a third, I don't know, but just trying to ensure that it's not seen to be a biased list that you're creating. Then number 3, you also need to, when I say you now, I'm talking to us as lawyers, if we are representing the employer in the redundancy, and even if you are representing an employee, things you'll be looking out for to check and see that things have been done properly. So calculate the estimated benefits and entitlements of the employees. In a redundancy, most times the benefits are actually large, especially when you have unionized employees. Get familiar with the agreements that have been executed. If there are no clear-cut agreements, but they're like industry best practices, get familiar with them. Find out if you have, be sure that you have the money. If you're winding up the business, it's almost not a problem except when you have creditors, because you know under our laws, employees are given prior consideration for payments before you pay off your debts, right? So you want to be sure that you have enough money to pay off the employees, their benefits, before you pay your creditors if you are winding up. But if you are still going to continue business, you want to ensure that you have sufficient assets as well to continue doing your business. I remember in our case at the time, we were threatened that if we did not pay the money within a specified period of time, the government was going to take over the company's assets, go to court, take over everything, sell the assets, and pay the employees. That was something that we're not willing to happen. So I recall also that the company had warehoused those benefits in an offshore account where it felt it would be safe, outside the reach of anyone that may be tempted to take money from there to offset any existing debt. But there were agitations at the time that the money should be brought into Nigeria and put in a Nigerian account. You know how our people can be sometimes. They're like, no, the money is in the US. We are not seeing it. The bank can just take the money there. Let them bring it to a Nigerian bank that we can see. CBN should be aware, you know. So we had to then engage and show documentation that this money was actually warehoused in a foreign account and nobody was going to use it because it had expressly stated to be used for this purpose. So ensure that you have the money. Number 4, when you are sure that you have ticked 1 to 3, then you have to call the trade unions, where you have trade unions or employees representatives or the employees who are affected themselves. You have to call them and let them know what is going on. So from 1 to 3, it's very good to ensure that you have strict confidentiality. In fact, I understand that most companies may not be willing to do this in-house. Perhaps their in-house counsel will be working with their external counsel, because when you have too many people in the organization sharing information about this, information can filter to the wrong place and then problem starts. So from 1 to 3, manage information as much as you can to ensure that it's only revealed to people who you want to get that information on a need-to-know basis. Then from 4, ensure that whatever you are telling the union is true, that the facts are clear, that you are not bamboozling or they are not seen to be taken for a ride. Also, the way that information is to be passed on matters, because life is involved. If you are informing people about this and somebody passes out and dies, for example. So it's good to create a humane environment, appreciate the employees for the work they have done so far, disclose the company's records as much as you can, the profits and losses you have made, the arrangements you have made to take care of them if the company decides to stop doing business in that particular area, the type of people who will be affected and the arrangements you have made for them. If possible, create room for counseling, because if somebody could go home and commit suicide, for example, so how would the entity treat that? Even if you are not going to be seen as being held liable for that suicide, it will be a reputational damage that may affect companies that care for their reputation. So where required, you need to get regulatory approval. Um, the interesting thing is that in the oil and gas industry, which is almost like the cash cow of the company, of the country, I beg your pardon, there is now this requirement, which has always been there. And funny enough, I'm not sure that it has been challenged because nobody really wants to get in the bad books of government. The investments in the oil and gas industry are very huge. If you suffer a loss, you suffer a very heavy loss. And when government has already made a regulation now, it's difficult to go and challenge that regulation because it is a regulation, by the way. So I don't know. I'm just thinking now because the regulation is to the effect that you cannot release a staff, whether by redundancy or termination, without getting the approval, the prior written approval of the DPR. So the question I was always asking at the time was, okay, did you need the DPR's approval to engage the person in the first place? And if you did not, and an agreement was signed and you have your company policies and you go to the DPR and for some reason approval is not coming quickly enough and you have to keep paying that employee, I don't know how that is going to impact on investor confidence in coming into the country. I guess the regulator has his own way of dealing with it to ensure that investors are not do not feel bad. But I remember in 2015, 2016, when the industry was really at oil prices had plummeted and things were not very good for the industry, there was a ban. There was actually a ban from the president, who is also the Minister of Petroleum Resources. He had banned companies from terminating the employment of personnel in the industry. But then so many people could not cope. Like if a company is clearly in distress, so what companies were doing was applying on a case-by-case basis, pleading their case, stating, I remember we worked for a client at that time that had to then almost like open his books to show that, look, we are in the red and we cannot continue. Our offshore parent is also bleeding and there's no way we can continue to keep this personnel. So it's almost like justifying that you cannot continue to keep the personnel before you get the approval to release them. And the consequence for failing to comply, if you decide to call the bluff of the government and go ahead and release personnel without getting the requisite approval, there is a monetary fine of 10 million. There is a compulsory requirement to restate the released staff, in which case you have to pay the salaries up to the time of the restatement, and also the tendency to suspend the company's operational license. Now, in the industry where they say they want to suspend your license or your lease, it's not a joke. And when that happens, it's almost like losing everything. So companies are forced to comply. And the teaser here is whether this can be classified as regulators' interference with contracts of employment, and whether it impacts on the rule against forcing an unwilling master on an employee. So if the company, for example, is no longer able to take on that staff, and the regulator is saying, okay, we know that people working in the industry are basically taking care of a lot of unemployed people in this country, and if you let them go, it's going to cause a very serious security risk, because many people would have lost their means of livelihood. Security would be a basic problem, and as a matter of public policy, continue to pay these people. Does that interfere with employment contracts? Tutu, do you think we should, what do you think? What do you think? Should we allow people to say one or two things on this teaser for like 10 minutes? And if you have any comments too, please carry on.
Yes. No, that's fine. We can open it up and then.
Okay. Jamil, please, are you able to allow people to just contribute to the teaser?
Okay. The teaser, is it teaser or teaser? Okay, yeah. So the thing that can this be classified as regulators' interference with contracts of employment and impact on the rule against forcing an unwilling master on an employee? Okay, you're talking about the DPR guidelines. Okay, so I'll just unmute and let's see who has something to say about that. 1 minute, please. Okay, so anybody?
Jamil?
Okay, who is that?
Jamil, this is Mary. Can you hear me?
Okay, Mary,
Yeah.
let's have your view.
Dude, I can't hear you.
Mary, please go ahead.
I don't know.
Hello, Mary.
Hi, Jamil. Can you hear me?
Yes, I can. Please go ahead.
Okay. I was going to say that I don't think that I will take the view that this impacts that this necessarily means that it's an interference on that rule. By statute or by regulation, could modify common law, and this is pretty much common law. And even though I understand at the time when those regulations were passed, why they passed it, it's up to the regulator or a government authority to decide, how best to approach. It's pretty much what the NIC is doing with its quote and unquote looking at the facts of the case and determining whether it was really an employment arrangement we had or whether it's a consultancy or whether it's the fact that they are doing that and sometimes coming up with judgments that maybe some 10 years ago will not have had does not mean that they are necessarily foisting. They're just saying that there's a process you need to follow, and if you follow that process, it may take you much longer than you ordinarily would have just preferred your 1 month's notice or 2 months' notice. But it's a process. They're not saying you can't sack entirely. They're saying if you want to sack, you need to come. I don't take the view that it impacts on that rule. It just adds a layer. It's also, I think the closest that we have is in the private sector is directors. So if you want to remove a director, there is a process. And if you don't follow that process, even though you think you have removed that director, you're back to square one.
Okay, is that all, Mary?
Yeah, those are my 2 cents.
Okay. I think we'll just take one more. I don't know whether Olumide has something on that. He has his hand up. Okay. Olumide, is that you?
I can't believe this. I lost my work.
Hello, someone else has a view. The person with the iPhone.
It's me, Jamil. Hello, Jamil.
Introduce yourself.
Hello, Jamil.
Okay, now so, yeah, introduce yourself.
Yeah, good evening, ladies and gentlemen. My name is Nonsoazi. I take it off from where Mary stopped. And I think it's an issue of public policy because redundancies do happen. My only concern is that, and I was thinking that maybe the presenters will help us with instances where redundancy has been questioned, because what I have discovered is that even while I was telling
I'm not happy at all.
there are times that employers will, masquerade under redundancy when what they really want to do is to redundancy. I mean, to what extent can you actually verify the reason? Do we have an instance where we inquire? To what extent can you go to show that there was a reason for redundancy? And again, then I mentioned something that if you render someone redundant, you don't have to fill that position for 2 years. Is it specific? I don't think I've seen any statute that said that maybe case law and say you have to leave it open for some time, because sometimes you can do a massive redundancy and before you know it, the economy changes and all that. So I think it's a very serious issue of facts. I mean, that have to be dealt with. Every particular case has to be dealt with its own unique facts and all that. So, but the particular area that I want us to talk about, I mean, because what Mary said is very clear and all that. And I don't think one should see it as such, because redundancy goes beyond termination. Redundancy is more like, I am letting you go because I can no longer pay you. My structure has changed. It's not like you are not performing very well. So I think the public policy has to come in there to reform what common law has, that you have to go through this. So it becomes like a litmus test that you must pass through to be sure that the reason you are giving, coincide with what government or whoever is the maker of the public policy really wants. But I would like us to throw more light on instances where the court has questioned or declared that, oh, this is not a typical case of redundancy, because anybody can come and say, oh, I mean, for instance, I work in a terminal, a terminal operator. They can say, oh, because of this, because there are many reasons to declare redundancy. To what extent can the court go, to actually prove that this is a deserving case of redundancy by taking bread out of somebody's mouth and all that? Thank you.
Okay, thank you, Nonso.
Yeah.
Are you willing to take one more comment on your teaser, or do you want to continue? Hello? Hello, Nena.
Hello, Jamie. I think she's on. I think you muted her. You need to unmute her. Yeah.
Sorry.
Hello?
Okay, yeah, Nena.
Okay.
Yes. Okay, so I was saying, I
Comment
think
on the teaser, or do you want you guys to go on?
okay, so I was saying, subject to Tutu's view, that we can go ahead and take one more comment, and then
Okay.
Tutu and me can address the comments that have been made before we continue.
Okay, so does anyone else have anything to say about Okay, I think we should continue.
Can you? The background noise is too much, please.
Hello.
Jamie, please mute everyone again. Okay.
Okay, everyone is muted. Okay, continue now.
Okay, thank you. So I agree with Mary that to the extent that yes, we can add one more layer of the process by saying you need the regulator's approval. That's fair, but I would beg because I think we just need to put ourselves in both carts here, that there should be a time frame at least, where the regulator is allowed to have an infinite period to give consent or not. I'm not very sure that would be fair. That would be considered fair, especially where the requirement is that regulatory approval should be given prior to commencement of the redundancy. At least information flow should be done, should be speedy enough for clarifications to be given where required, and where the approval is not given, reasons should be given for that. If the employer has to give additional information, just to ensure that that approval is given within a specified period of time, which is fair to both parties. Because the risk of doing otherwise is that the employer may be stretched to the point where it eventually has to close shop completely. So if it's an employer that is probably going through some financial issues and is just trying to downscale and reorganize itself to continue doing business, and for some reason it is stretched to the extent where it is not even able to continue doing business and exit, I mean, I think that is also a loss for the country anyway, if at the end of the day what happens is a winding up and not just a redundancy. So in as much as we want regulatory interference, reasonable regulatory interference, I think it's fair for there to be a reasonable time frame for necessary approvals to be given. So do you have any comments on this?
No, I just wanted to clarify, something that Nonso said when he was giving his comment, and that was about period of replacement after redundancy has been carried out. There's no statutory, so when I mentioned 2 years, it was an example that I gave. There's no way that says that you cannot replace within 2 years. But like you said, it's facts, it would vary depending on circumstances. So for instance, if the reason why you're carrying out a redundancy is because of the economic downturn of that particular company, then of course, if things pick up a year after or 6 months after, nothing says you cannot hire. But if the reason for the redundancy is that that function no longer exists, or you're no longer performing that service, then you cannot 3 months down the line or 6 months down the line say, oh yes, by the way, we are recreating that department. That's what we're trying to say about the fact that you cannot replace or rehire that particular position very, very soon afterwards.
Okay. Thank you, Tutu. And also on the points, the question that also asked as to instances when, whether there have been any instance where redundancy has been questioned. I think I saw a few cases in the NIC's box of cases, judgments, where redundancy was challenged primarily because the employer did not follow the process, trying to cut the benefits payable. So in such instance, when the court gave the judgment, the employer from the cases I saw was asked to pay the redundancy benefits, full redundancy benefits up to the date of the judgment. And I think that's probably because if the employer is not willing to continue to work with the employee for any reason, you cannot force the employee to stay in the employer's workforce. You can't compel the employer to take the employee on. So the best is to give that employee maximum compensation to move on, which in a way may be like an indirect punishment for the employer that tried to cut corners. Because if you then have to pay the full salaries for all the months or years that the case had been going on, and then do the redundancy at the end, the benefits would automatically swell, and the employer will end up having to pay more than it would have paid if it had followed due process. I don't know if that addresses Conso's concern, but we can talk further about it at the end of the presentation. Number 6 on the list of conditions is the need to negotiate and agree on redundancy benefits that are payable to the affected employees, unless such benefits are expressly stated in existing agreements or policies. So the negotiation may be done directly with the affected employees or with the trade unions or representatives that are recognized as representing the employees' interests. Now, this is very interesting because I found that even where agreements had been, let me give you an example of what happened in the case that I worked on. So there was a collective, a condition of service agreement, which is more like a CBA, that had stated what would occur in the event of a redundancy. And when the company decided to go on, or when the company decided to inform the unions that, okay, it was going to carry out a redundancy, the unions tried to twist the company to revise the terms of the existing agreements to expand the redundancy benefit. So there were arguments like, okay, this agreement should have been renewed by now, or no, we want to actually revise so and so provisions. We're not going to. So there were instances where they kind of, what was the word now, blocked the employer's place of business, were playing music with canopies, disrupting work from going on, down tools, went on strike because they were, and even took the matter up to the regulators, insisting for such amendments to be made. And of course, these things are very clear to everyone. And in the absence of any unreasonable bias or some factor that is preventing the regulator from acting, the truth is very clear. If you have a clear agreement, you have clear policy documents, you have clear industry practices that you are following, and you are asked to, you are being compelled to pay more. I think a regulator that is fair would expressly make it clear to the unions and affected workers that this, especially when the company is seen, when the employer is seen as acting in good faith, when the employer is expressly seen as acting in good faith and not trying to shortchange anyone. To the best of my knowledge, the regulator, especially the Ministry of Labor, would lean towards the employer's side in such instance, where you have done everything that you can to ensure that full and fair benefits are paid to the affected employees. Then number 7, it's advisable to execute severance agreements with the affected redundant employees. So once you have cleared everything from the regulator, you are sure that the regulator is going to give you a thumbs up to go ahead. You are sure that the employees and the affected trade unions are on the same page with you. Please go ahead and execute severance agreements, which would kind of extinguish all claims upon the execution, and then you pay all benefits that are outstanding to the affected employees. Also submit such severance agreements to the relevant regulatory authority. Now, there is a point that we added here that you should be aware of employees who are indebted to the employer. I remember in that case that part of the problems people had was that they had borrowed money from the company. Some had borrowed money from the employers' cooperative association for employees, and the debt was high above the redundancy benefits. So if an employee was indebted to pay 10 million, for example, maybe took a loan to buy a house or took a loan to do something, and is owing 10 million, and the redundancy benefits comes to 8.5 million, for example, that means even if you are giving that, you won't even be giving the 8.5 million, because ordinarily they should take it to pay off the debts that are outstanding. So that was a major challenge, especially when you look at the Labor Act provision that prohibits or restrains employers from advancing loans in amounts exceeding 1 month salary to the worker. So a prudent employer should, as much as possible, try to ensure that it doesn't box itself into that kind of corner. And should you find yourself in that situation, you may end up having to write off some of the debts, because you cannot send the employee out without anything anyway. And that was why they were pushing to review the redundancy benefits upwards, so that people will be able to get something. So what the employer did in that case, I understand, was to kind of pay off some of the debts up to a certain percentage, so that people would not be left empty when leaving the employer's employment. So also note that where the employer fails to comply with the steps, that redundancy may be declared to be invalid. And that also goes back to the question that Nonso had asked. In this case, Ster Nigeria Limited and Gazama, the employer did not comply with the steps for redundancy. The reason that was given for redundancy was almost a farce. And I can share this case with us, a copy of the case after this presentation. The reason the employer had given was almost a farce, and the court held that the redundancy that had been conducted was invalid because the employer had not followed the requisite steps for conducting a redundancy. The reason that they had given to the employees was false, actually. So in that, the employer was mandated to pay all outstanding salaries and then do a proper redundancy and pay the full benefits that the employees were entitled to. So you see that an employer that tries to cut corners may just end up spending more, because the employer had to pay for the entire duration that the matter was in court up to judgment, pay salaries for that period, and then start paying redundancy benefits, which would have, of course, accumulated. So it's always advisable to do the right thing as much as possible.
Okay. Yes. Okay, so for this slide, we're talking about redundancy benefits. As Nana mentioned, the oil and gas sector probably pays the largest redundancy benefits. But generally, redundancy benefits are large. I mean, that are paid by companies are fairly large. And this, in my view, is contradictory, especially where the grounds on which a company is carrying out a redundancy in the first place is economic downturn. So the company is saying that, look, I can no longer afford to have these people on board. I'm expected to pay out so much money. But in any case, that's how it happens. There's no provision in the labor law and the Labor Act for redundancy payments. The only requirement is for you to negotiate, to use best endeavors to negotiate this. We must mention that the labor law empowers the minister to make regulations, but to date none has been made. So in the absence of any regulations, redundancy payments are generally paid in line with a collective agreement or company handbook, contracts of employment, or individual contracts of employment. Okay, so So Nigerian court decisions support each of these sources as a reference for redundancy payments. I would mention one case. I think I'm not one for cases, but I think this one I know is Ajayi against Texaco, where it was said that the redundancy provisions contained in the employment handbook was binding on the parties, and they didn't have to. That was it. As the employer had already signed the handbook and had signed it, yes. Okay, where there's a union, you would oftentimes have to discuss this with the union. The employer would have to discuss this with the union. This is not mandated by law, but and doesn't vitiate the process if you don't reach an agreement, but that's how it happens. Yeah. Okay. Redundancy packages are usually within the full discretion of the employer. So the employer dictates, for the most part, except when they're negotiating with the union, they typically decide what it is that they're going to pay out as redundancy benefits. But so what companies typically do is look within the industry what their counterparts are paying, and that's what we find. So, for instance, the oil and gas, you find that they pay similar benefits as redundancy benefits, or you see the banks or whatnot. But it's varied. So we see from monthly to weekly payments per year of service, plus the payment in lieu of notice. Sometimes there's an ex gratia lump sum payment that is made. But here, we've shared with you what is paid in, what is contained in a CBA for a certain oil and gas company. In this case, which I doubt is in any other company's handbook or CBA. I don't know anybody who would pay this. Of course, they'll pay your salary to the last day that you have worked, because that's your entitlement. In addition to that, they would pay your salary in lieu of notice. It might not be 1 month, it might be 3 months, depending on what your notice period is within your contract of employment, they will pay you that. Then they will pay you in some cases it's weeks, 2 weeks, 3 weeks, 1 month, 1.5 months, 2 months. It goes as high as it can per year of service, up to a maximum of 30 years of service. And it's based on the salary at the time that you are exiting the company. They will pay you your accrued annual vacation. Again, this is worked for, so this is not necessarily a benefit. They will pay you the bonus that you've earned for the year that for that year that you're being exited. They'll pay you gratuity. But like I said, this is for a specific company. So I think in this case, this is an old CBA, and at the time the Pension Act hadn't come into force, so gratuity was still paid. And I think that a few companies still pay gratuity. So here, it's graduated depending on your year of service. Then in addition to that, they would pay you ex gratia payments of 3 months gross salary. They'll pay you if you're out of station. They'll pay you repatriation benefit to bring you back to your to your initial place of employment, your initial base of employment. This would be, and this repetition benefits is for you and your family to bring back your goods, your car, was for everything, and then allowances, overtime, tuition, and whatnot. So I think this is specific to this particular company, but it varies in various companies, and it's like I said, especially for the year of service, the per year of service, it goes from as little as 2 weeks per year of service to as high as 3 or 4 months per year of service. Yes. So then I'll hand over to you now.
Thank you, Tutu. So in making the redundancy payments, it's also advisable to comply with the statutory deductions that are applicable under the law. Of course, we know under CAMA, the payments that take priority in the event of any winding up or for any reason the company is not able to continue doing business or wants to downscale. So employees' benefits are one, taxes are also prioritized. So all payee tax returns should be made to the relevant inland revenue service where the employees are residents. Also notify the state inland revenue service that such employees have ceased to occupy their position in the entity, just so the records are clear. And for NSITF as well, the Nigerian Social Insurance Trust Fund, there is also a requirement under the Employees Compensation Act to make certain returns within 30 days from the date the employee stopped being in the employer's service. So the general advice here is for the entity, the employer entity, to ensure that it engages credible tax consultants and advisors to ensure that the company is compliant. Because we know that when it comes to tax, even if the company is now a shell, they can go after the board of directors where the company has defaulted. So in paying off the employees, also ensure that the employer complies with statutory obligations for remittances, and we have personal income tax remittances, pension, remittances to the Industrial Training Fund, the Employees Compensation Fund, National Housing Fund, and of course the National Health Insurance Scheme and contributions. Just ensure that the books are properly closed for the affected employees. Thank you so much for listening.
We'll take questions now.
Okay, thank you very much for the beautiful presentation. I'm sure it's very enlightening. I had a couple of questions which I don't even think I remember now, but I'm sure I will remember if I go through the slides. So, for those who have questions, I think out of respect to those who have done it the proper way, we'll take their questions first. Those are the people who have typed their questions in the chat box. So if you have your own questions, this is the time to start sending them in through the chat box. So in the order in which they've been raised, I will read out the questions one by one so that you ladies can take it as you can. So that's to give you an indication. Okay. So the first question is from Tibola Fashogmo, and our question is: if a company lays off a large number of persons for non-performance probation period, is it redundancy?
Okay, sorry, Jamie, can you repeat the question?
Yes. If a company lays off a large number of persons during their probation for non-performance during their probation period, does that qualify as redundancy?
Okay, Tutu, do you want to take a stab at that?
Okay, I can try.
Okay.
So if you're laying off a large, no, that's not a redundancy. In my view, that's not a redundancy. No, that's not a redundancy, because if you've given the reason, if the reason you've given for laying these people off or for terminating their contract is because they've not performed for non-performance, then that's not a redundancy, because a redundancy is saying that those jobs don't exist, that position no longer exists. So I don't believe that that's a non-perform. That's a redundancy.
Okay.
Thank you, Tutu. I agree with her. No, I agree with you, actually. In fact, I saw a comment in the book of a learned author, that's Emeka Chianu, who is a learned author in this field in labor law. He's a professor of law at the University of Benin. And he actually expressly stated, I think he had a supporting like a case there, that where people are rendered or sacked rather during their probationary period, they are not considered as having been made redundant, and especially where the reason is because the employee is unable to perform. Remember that one of the conditions for redundancy, as we had stated, is that it must not be due to the fault of the employee. That is this slide that is currently showing under item V, that the employer must proffer reasons for the redundancy, and that reason is usually due to no fault of the employee. So if it is because the employee has become incompetent or is not deemed to be competent to perform the job, that's not a redundancy, that's a clear case of termination. And if it's done during the probationary period, well, opinions are well received if there is any, but I don't know if that will even be classified as a termination in itself.
Okay, that's clear. And I agree with you too, if I may say so. The next question is from Mr. Nyemadike, and his question is, what happens where the staff handbook has a definition of redundancy that runs contrary to the statutory definition? So can you have a handbook saying, for our own, redundancy is when you are sleeping on the job and you are redundant, you go. And, to even give a background to this question, now that he has mentioned it, I have actually seen that kind of handbook before, which says that a person can be rendered redundant for, what was it? If, yes, I won't mention. In fact, a person from that company is within us here, but I won't mention his name so as not to embarrass him. That last point that we made about performance, that you could be rendered redundant for non-performance or poor performance, and you can be rendered redundant for misconduct. So I think there is a confusion as to terminology with such handbooks. So Yema's question is, based on all this principle of bindiness of contract and all of that, can an employer decide on his own what qualifies as redundancy, contrary to what is in the Labor Act?
Okay, I think the answer to that is pretty much simple. Going against statutes cleverly on your own, trying to go against what the law says. There's a difference between misconduct, in which case if you want to go through dismissal to dismiss the employee for misconduct. And I think I saw a case in Professor Emeka Chianu's book, which I was just trying to find, where it's something similar, where the employer had said, okay, for this reason you are now rendered redundant, maybe something like a misconduct, and the court was like, there's a difference between misconduct and difference between redundancy and dismissal. So just because you decide to coin it the way you would want it to be, I don't think that would be binding or held to be binding in any court of law where it is expressly against clear provisions of statutes. I don't know, that's just my own opinion. That's what I think.
Okay, I agree. Okay. Next question is from Mr. Adisa Oluwole, and his question is this: can employees brought through outsourcing be declared redundant? And if the answer is yes, who pays the redundancy benefits, the recruiting agency or the end user?
Thank you so much for that question. In fact, we had an instance where that happened. So these people were outsourced employees. They were employees of a third party that had been outsourced to the company and had worked with the company for over 10 years, some of them. You know, you've worked in a place for 10 years, they are treating you chummy, you get all the benefits, and at some point the lines become blurred and you begin to think that the entity where you go to work every day is your employer. And it happens to be this same entity that I was talking about earlier in the presentation. So when they decided to downsize, they started with third-party personnel, notified all their third-party services, all their personnel providers that they wanted to terminate the contract. Of course, they went ahead to terminate as a contract. But I would just add that the lesson I learned from that is as much as possible, if it may be a bit difficult to manage because you will not want to be nosy. But what happened in that case was that the third-party service providers had executed CBAs with Newpeng and Pengerson, and those CBAs did not mirror the agreements that they had signed with the company that they were outsourcing the labor to. So they had less amount of money to offset their liabilities under the CBAs. And when they received notice that their services were no longer required, of course, they had to pull out their employees, and their employees decided to protest in the place where they were going to work every day. And they actually tried to harass that company that they had been outsourced to. I recall that when the matter was taken to the Ministry of Labor at state level, it was a consensus that, okay, this is not your employer. The person you signed the contract of employment with is the outsourcing company. So it is also very important for the company receiving the employees to be careful. So you will not, I think I saw it in one of our chats on Elan WhatsApp, that some employer decided to hand over a termination notice to a third-party staff directly. So that's not advisable. If you, in fact, you cannot do a redundancy on another person's employee. If you do not want to continue with whatever agreement you have with the service provider, please notify the service provider. The service provider will follow the steps laid out in the agreements, and that's why it's also advisable to ensure that the agreements are clear as to the time frame for withdrawing the personnel. If of course it's wise for you to allow for that notice period or payment in lieu of notice, so you pay 1 month in advance so that they call the employees and pay them off. But if the service provider has gone ahead to execute agreements with unions or sign agreements with the employees that are beyond what is entitled to get, then that will be a very sorry situation. But it will be very wise for the company receiving the employees to ensure that it is as distant, it stays as far away as possible from interfering in that process. Otherwise, it may be called up to take on some of the liabilities. But in that case, as a matter of fact, I think the company, out of its magnanimity, decided to increase the monies that the service provider was entitled to in order to enable the service provider to offset some of its liability to the entities. And most of those service providers had to wind up because it turned out that many of them had set up solely for that purpose of providing personnel, and money was no longer available. So the best option for them was to wind up, pay what they could. And of course, you know, when the company is dying, you take what you can and you go. but it's advisable to ensure that you do not allow a service provider to engage beyond what it would ordinarily receive from.
Okay.
I don't know if I've answered that question, or if Nyema, the person who asked the question, has any.
Okay. If you want, I have an opinion about that answer anyway. But let me unmute the person that asked the question to ask if he agrees with your answer, or he has any other clarification to make. And that has been bad because I don't think we gave the other people the opportunity, but I guess we will. So that's Adisa Oluwole. So Adisa, I'm unmuting you now. What's your reaction to the answer given by Nena?
I agree with the answer. I agree with the answer completely.
Please introduce.
Well done. I agree. My name is Oluwole Adisa. My name is Oluwole Adisa.
Hi, Wale.
And I agree with the clarifications. Thank you very much. I really appreciate the way you handle it. Good analysis. I agree. Thank you very much.
Okay, me, I don't fully agree anyway, or maybe I should say I have a clarification to make. Thank you, Adisa. Okay, now, the reason why I said so is this. If you look at the law on redundancy, at least from Mr. Tutrip's standpoint, the provision is only present in the Labor Act. And if you look at the definition of an employer, or an employee under the Labor Act, I think that should be section 1. Really is wide enough to cover employees from third-party agencies. So if that is the case, can a company, from the scenario you painted, someone has been working with you for 10 years, and then redundancy. The reason why you are letting them off or even terminate the employment of these people is that there's a downturn. So, and then instead of paying everybody off, you now say, for you third-party people, go and meet your employment agency, who you expect will then initiate another redundancy for their own employees. I don't know how that would work out, especially in the light of recent decisions we're having from the NIC, where they're able to say, look, maybe in terms of control and the facts and circumstances, these are your employers. And then interestingly, look at that case between Mobile and the spy police officers, for instance. I think it's somewhat, if not on all fours, very similar. There was a case of Mobile and Johnson. What's the name of that? The lead plaintiff. People who were spy police officers, supernumerary police officers employed through the Nigerian police, and they were working, and then I think there was a layoff or whatever by Mobile. And then the police officer said, oh, pay us as your staff. And Mobile says, oh, you're not our staff. You are police officers. Go and meet the police commission to be settled. And I think the Supreme Court just gave a decision maybe last month saying these people are your employees. Although in that case, this is the way they were employed. Yeah.
If I may just butt in on that Mobile one, just for my own understanding now, for me to be clear. Because when I read the commentary on that case, it appeared to me that decision was based on the fact that those spy policemen were specifically recruited with the understanding that Mobile would be fully responsible for them. That was the understanding from the Nigerian police force. And I think, please, I'm happy to be corrected if I'm wrong. Like there was some kind of documentation that implied that they had been transferred to Mobile.
I consider that.
So exactly. So the Nigerian police force stopped being responsible for them. It was almost like Mobile was paying them directly or something. And when it came to like the lines of the lines were blurred. It actually appeared like they were Mobile staff. So I'm just thinking that was probably the basis of that.
I agree with you. You're correct. You're correct. But but I think that could still be argued. Okay, so that we don't. Let's go on because Hello.
Hi.
Okay. The next question is from Mary, who is asking if redundancy payments, apart from the salary or contractual benefits, are taxable. Are redundancy payments taxable?
Yes, I'm back. It's me.
Okay,
No,
there's nothing in the law that says that they are not taxable.
no.
So to that extent, in fact, allowances are taxable. I don't remember seeing anything under the laws that says you cannot tax benefits received at the point of redundancy. So
No,
yes,
Nana,
please. Yes.
if I may. So I think that because I think we had a similar, I've expressed a similar situation where
Okay.
the tax authorities drew a distinction between terminal benefits and termination benefits. So I think termination benefits were taxed, but terminal benefits were not. So in this case, you would ask, the question is, what's the difference between terminal and termination? But I guess, yeah. But in this case, in any case, the redundancy payments were considered terminal benefits and were not taxable.
Okay. Thank you. That's a new one for me, and that's why I will always say it's good to get the tax consultants to be able to engage the necessary authorities and do the right thing. Yeah.
Okay. The next question again is from Mary. Okay, it's a long one. She has a preamble, middle, and conclusion to her question. So let me take time.
Okay.
She said, the statutory definition of redundancy is contained in the Labour Act, which the courts have held do not apply to employees who are not workers. In practice, CBAs also mirror the provisions of the Labour Act. In view of this, other than in relation to workers and employees who are members of a trade union, is there a basis for stating that there is a statutory definition of redundancy for all categories of employees? Did you get that?
Yes. So the way I would approach that is looking at what the NIC has been doing this past few years ingeniously, using the Labour Act as a minimum standard for most of the cases that they've had to deal with. So like even I remember that for that particular client, for example, some members of management were affected by the redundancy, and for some, almost like the Labour Act was not applicable to them. It was just advisable that they benchmark with the Labour Act, and those management staff were not unionized, by the way. So it was just a question of their employment contracts and the company policy, but then also benchmarking with the Labour Act and industry best practices. So I would just say that I think just showing what the core courts in this instance has been doing, which is using the Labour Act as a minimum standard. And most of the cases that I actually saw in the NIC's box of cases, most of the people involved did not appear to qualify as workers, if you look at the definition of workers under the Labour Act. But the court was more often than not leaning towards the Labour Act provisions in dealing with.
Okay, that's an interesting question from Mary. I guess another way of looking at a question is not even with regards to the benefits itself. I guess it also raises issues about whether you can say there's even provision for redundancy for someone who doesn't fall under the definition of a worker. So if you are not a worker and there's a mass sack and you are not a worker within the Labour Act, will you then say that there's an obligation on the employer to start paying redundancy benefits? So I guess our statutory redundancy payments, or the whole idea of redundancy, is it statutory or common law based? Is there a common law?
What I was just about to say.
Yes.
Yeah. That's what I was just about to say. So even if you are saying, okay, you don't want to go by statutes, what does common law have to say about that? And ultimately, what do the courts have to say? Because in the event of a dispute, they would decide. And what have they been saying over time? Which can be challenged to get another decision. I don't know.
Okay.
So,
Now,
do you have any comment on this?
I'm sorry, Nana and Jami, sorry, before we move on, I wanted to quickly clarify this. So I just opened the documents just to be sure that the statement I made earlier is
correct.
accurate. So it's a public notice from the Lagos State government on compensation for loss of employment. So it says there, so what it says is, so firstly I should say that the Personal Income Tax Act is what exempts the redundancy payments from tax. It says clearly that payments made as compensation for loss of employment is not taxable, but it is subject to capital gains tax, not personal income tax. And the distinction I was talking about is the termination benefit is statutory, so it defines what termination benefits and what terminal benefits is. So it says that termination benefit is where you're made redundant and get a settlement payment. But when you retire, that is terminal benefits. Yes? Yes. But when you have a fixed term contract and this ends, this is also termination benefit. So I guess for the only one that is terminal benefit is where it's retirement. All the others are considered termination benefits and are only subject to capital gains tax. Yes, so sorry.
Okay, now Tutu, before you just hold that thought, before you go ahead, I think it also dovetails into the next question from Nonso, I believe, as to his question is for you to provide him with the case law that differentiates between termination benefits and terminal benefits. But from what I hear you say now, it seems to be more about a policy directive of the Lagos State government. So
yes.
Is it just that, or have you come about any case law or statutory support for distinguishing between termination benefit and terminal benefit?
No, I haven't. No, there's no case law. It's just this notice from the Lagos State government.
And I think the Lagos State government is playing the ostrich. I really don't agree with all those notices.
Thank you, Tutu. If I may just read what the payee regulations say.
Yes.
Maybe just to even help me to also understand. Tutu, thanks. It says that an employer should write to the tax authority of the state in which the employee was resident during his employment, providing a certificate in a prescribed form stating the employee's name, tax identification number, address, date on which his employment commenced, date on which his employment ceased, details of the relief from income tax, cumulative emoluments, and corresponding cumulative tax as at the date his employment was terminated. So that's Regulation 4 of the Operation of Pay As You Earn Regulations 2002. I'm also trying to make sense of it.
Check that bag, there's biscuits. Open that bag.
Okay.
Let me should mute some people.
Please mute. Yeah, ma'am. Hello.
Hi.
Okay. You may continue, please.
Sorry, hi, Jamie. Can you hear me? Before you guys go on, I think on those questions, and actually just ask a rhetorical question. What I do is circulate something because we've dealt with this a number of times in-house. I will circulate advice we've given on this and the PITA provisions that deal with this.
Okay. Thank you. Thank you so much.
Okay. I think Yema had something to say. They seems to be busy. Okay, so are there any other? Okay, Yema, are you still there?
Daniel.
Yema, you wanted to make a comment?
Yes. It's still on this statutory definition and contractual definition of redundancy. Somebody made mention of the fact that while the Labour Act defines workers, and from our general perception, we've always had the view that, which I think is right, that the Labour Act does not apply to employees because they are not covered under the Labour Act definition. Now, I have a case that if any of you have checked the NIC website, perhaps that case might have been reported. It has to do with one Mr. Charles Sugeli and 3 others against Access Bank. I am saying this because I used to be there, but I left them. The definition. Hello?
Yeah.
Yes.
Hello?
We're listening.
Okay, the Access Bank's handbook of redundancy is quite different. In fact, that's why I asked the question. It's contrary to what the Labour Act states. Access Bank's definition of redundancy is that once an employee is involuntarily asked to leave or involuntarily terminated, it will be treated as redundancy. And so, based on that, my question was, what will now happen? Will we now say, okay, since the Labour Act says when there has been excess workers with less work to do, that we can declare the redundancy? How do we reconcile that too? Secondly, I noticed that in that case, the NIC didn't even bother itself with the Labour Act. It focused mainly on the Labour contract of employment and the handbook in holding that. Look, these 3 persons, there are just 3 of them. These 3 persons were asked to leave, and so they have been declared redundant, even though their position was occupied by another people immediately. So that again seems to be contrary to the understanding Tutu and Nena gave us from the inception of their discussion. So I want them to throw. Let's see how we can throw more light on that and expand on that issue, please.
Okay then. Tutu and Nena.
When they're done, I have something to add.
Okay, no, so I'm sorry, Nyema. I was just trying to get the exact question you're asking. Is it as to the definition of redundancy, or if you're just able to repeat in one sentence, I would appreciate it. Hello? Hello?
I'm trying to team.
Okay.
Yes.
Or Jamie, you can paraphrase if you
paraphrase this question. What he's saying is that we have said that the Labour Act has a what's it called, definition of what constitutes redundancy, or what instances where redundancy can be said to occur. But he's saying an example that Access Bank has defined redundancy as any situation in which an employee has been asked to go will qualify.
Okay. Hello?
That the court did not even bother itself with issues about the statutory definition. Hello?
Yes, I can hear
Hello, can you hear me?
Yes.
So, didn't bother about the statutory definition and wanted you to reconcile that.
Jamil, so the court did not bother about the statutory definition, but just talk the definition in Access Banks or the bank's handbook, right?
Yes.
Okay, so that definition
means they were rendered redundant.
Okay, so if you ask me, and this is me just thinking as a free human being now, so I'll beg that you all pardon if this does not appear to align with any law, but I'm just analyzing what's the word now? Just trying to analyze logically. So the Labor Act has said if you have excess manpower and you're laying people off, and you're laying them off involuntarily, as in they do not want to go, but you're asking them to go, that is redundancy. Now you have, and the essence of that Labor Act definition from what we have seen is that redundancy benefits are actually higher than termination benefits in most instances. Now you have an access bank or a bank that is defining redundancy as any situation at all in which somebody is laid off, right? Right?
Yes, yes, yes.
Okay, now to my mind, I think that even puts the employees in a better situation. And I do not think that a court will readily challenge that definition because it just is broad enough to cover what the draftsman may have intended under the Labor Act anyway. So under any circumstance at all that you are laid off, you are going to get your redundancy benefit, which is bountiful. That's good news for your employee. But if you now decide to streamline the redundancy situations to instances that are kind of ridiculous in a way that puts the employee at a disadvantage, I think that's when the court will frown at it.
I agree totally with Nena. Exactly what I had in mind. I mean, the court may have looked at it and said, okay, if by your own definition you are willing to pay more money to the employee, so be it. Because if the court held otherwise and said, oh, this is not redundancy, this is just a mere termination, then you would have seen the employees getting just 1 month's payment in lieu of notice or whatever. But redundancy would have given them far much more. It may be responsible for that decision. Otherwise, I also agree that that decision was not given in accordance with the act. Let's just put it that way. It's allowed to say it's wrong. Yeah. Okay. So the last question, so that we can end this, because we don't want on and on and on. The last question is just asking if a company targets non-performing employees at the point of redundancy, I think these have been answered before. Can same be challenged under any imaginable circumstances, given that redundancy entails no fault of employee? I'm not sure if you understand that question. Did you get
Hello, Jamie.
Okay, the question is...
Yeah, okay, carry on, please.
Hello, Jamie.
Yes, please.
No, I think we have mentioned about this before, but I'm trying to paint a scenario. I mean, if a company has decided to declare some people redundant, and it appears from all indications that they're not tying it to, oh, there is nothing for you to do, or we have mechanized and all that, but they don't look at, okay, who are the people who have not really been adding value, you know? But what my mind is taking me back to is what Nyema has said now. You know, in that case, as against terminating that person's employment for non-perf, because we have to draw a line. I am struggling to draw a line between outright non-performance and in the estimation of the company and not adding value. Because somebody can be performing and the company then says, oh, these are the people that we have to render redundant. Because if you look at the semantic, you find out that somebody can actually become redundant even when he's still working, even when he's not outrightly incompetent, you know, which underscores what Nyema has said, that I think we shouldn't really restrict ourselves to that labor law interpretation. You know, if I am to give my own personal opinion, I think the ambit of what constitutes redundancy, because in some cases it's never clear. The company may still be able to pay them salary for 5 years, but they want to lay them off at this particular point in time because it is just logical and it makes business case to lay these people off. Not that they don't have the money to pay them and still make profit in the next 10 years. So that's where I'm coming from, you know, so that we don't really restrict ourselves that, oh, it must be that you are work. Because I'll give you an example. There are people who I know who were laid off. They were laid off because they feel that 4 persons can do this job. And when 4 persons started doing that job, it now got to the point where they were being overstretched and all that. Nobody went back to call them back and say, oh, you know, so it is really a gray area. I like this topic because you can never really box into a corner and say this is what redundancy means and all that. It should, it's the option should be open aside clear cut termination. And why a company may want to do redundancy as against termination, even though it's more expensive, is that termination comes with bad blood more than redundancy. Redundancy you can explain that and say is redundancy, but if you continue doing termination, they will see you as because of a relationship. They can say, oh, you are just laying everybody off, but they can hide under that garbage of redundancy. People will understand it more, even though I'm going to pay more, but I need to lay XYZ off. I don't know whether what I'm trying to say, makes sense. So we shouldn't look at it as if it's more profitable or it's less expensive to sack than to render redundant. Some companies may have their image to protect. I don't keep sacking people every day, but let me just declare that high level that English redundancy and all that. So I don't know whether it makes sense.
Please, if you're able to just thank you so much. But if you're able to just say in one sentence what's like a summary of what your point is now, I really appreciate it, so I can know how to.
What I'm trying to say is that if a company declares redundancy, and the people who are removed are mostly people who are not adding value again to that company, can that action be challenged?
Okay.
They have called it redundancy, but in practice, in effect, the people that have been applying or that have been penciled down to go are people from all indication. The company deems it that they are not adding value to the company. It may not be so clear. Yes. How do you approach that?
Okay. I was just trying to, that's the managerial discretion, because I was trying to understand whether the question was coming from the fact that the company did not have any reason anyway out of all those instances we had given, but just said these people are no longer adding value, we want to take them out. So what it essentially means to me, my mind, is that the company is saying it has excess staff than it actually requires. And it has decided to apply the managerial discretion under the last in, first out rule to consider circumstances in cherry picking people that it wants to take out. And has said take out people who it deems not to be adding value to his business. So that is still a redundancy to my mind. I don't know if I have, if I'm trailing your train of thought.
I think you answered it beautifully. Both of you are saying the same thing. I agree. There's discretion in even in redundancy to then look well, but then that discretion comes in as an exception to the last in first out rule. But what Nonso is saying is that there are no operational reasons, and you just decide that this person is not adding value, let him go. When you say someone is not adding value, it could be one of either of two things. It is either you are saying that, and I think you alluded to that in creating the scenario the first time. It's either you are saying, we have 10 people here. This job is something that 4 people can do conveniently. The rest are really excess to manpower. That is what it would mean. They are excess because we can have the same productivity by having less people. So the rest of you are not really needed, or you are not adding value in that sense of excess manpower. It is still a redundancy. But what if what you are saying is that we don't have any financial constraints, we don't have any operational reasons, we don't have excess manpower, we don't need to watch our numbers and all of that. We just think that you have gone lazy and all of that, and we render you redundant. That is not redundancy. That is termination for non-performance. It doesn't fall into the, the definition. That's what I think. Okay. And at this point, I should say a very big thank you for our facilitators. It's been an interesting session. For those that have asked for materials, I would ask that you drop your emails later, and the presenters can forward the materials to your email boxes. We can have further discussions on this, the WhatsApp group. Thank you, Nina. Thank you, Tutu, for creating time. We've had 2 hours.
More than 2 hours.
Sorry?
I said more than 2 hours.
Yes, 2 hours, 15
More than
minutes.
2 hours.
Thank
Yeah.
you. Thank you so much.
So thank you all for joining us. See you next month for
Thank
the
you,
next
everyone.
series. I
Bye.
believe it.
No refreshment anyway.
Yeah, no.
Blue ticket.
To unmute yourself.
How can two oil and gas lawyer like Nana keep me waiting for 2 hours? Nothing. It's not fair.
Especially over just banters.
Okay.